Hello, friends. It's your homie Joel. I thought it'd be great to jump off on a quick live here and tell you a little bit more about myself and how do I fit into the LawTube community. In the last two streams, I've given you examples of cases that I worked on when I was in law school on the plaintiff side at a private law firm. One was a wrongful conviction claim and another was a civil rights violation claim, an excessive force claim. And I actually have broader experience than that. I am an attorney. I'm 40. I got my license in 2023. I live in Omaha, Nebraska, and I'm licensed in Nebraska. I've also spent about 5 years or so living in Colorado. So I was able to learn a different system that really wasn't that far from home, but Colorado is a bigger place. They have more resources and their judicial system is more modern. They have more judges. And then politically they're different. The ideology is different and sometimes reversed and flipped. And so that's a good experience for me to get enough kind of immersion in that more of a blue state. And then Nebraska has been somewhat purple, but it's pretty much known as a red state. And that helps a lot for the law, legal training. Politics kind of goes hand in hand with law. They're supposed to be somewhat separate, but you can never separate them. You have the three branches of government, the legislature that makes the law, the executive that enforces the law, and the judicial that interprets the law. And the judicial is supposed to be separate from the political branches. It's supposed to be above the fray, and they're almost like monks, and they can just divine wisdom with enough patience, and then they just meditate, and then they figure out, okay, this is how things are supposed to go. But that is more of the ideal, and it can happen in practice, but it usually doesn't. But that happens to be my favorite branch, the judicial branch, just because for me, my personality, I am introverted and I really like deep thought and I'm interested in the truth. And I think that also my spirit animal is a sea turtle. And I have a tattoo of a turtle on my back because I went to Maui and went to Turtle Island and hung out with those turtles, my boys. And I really felt at home and I was inspired. So I got a tattoo on my back. And fun fact about SCOTUS, the Supreme Court in Washington, D.C., one of the decorative themes is turtles. There's turtles all around the courthouse, although I've never been there. But apparently, if you look at some of the pillars, there are turtles, and that's supposed to symbolize kind of the slow, steady branch that is supposed to be above the political fray. But it's one reason why it doesn't really work, or it can work, but one thing that makes it so hard is people are limited to their experience, and most people don't have the experience of all political spectrums. I went to Nebraska College of Law, and I can tell you, not to hate at all, by the way, on my Mormon brethren, because they're some of the nicest, coolest, most hardworking people. But we had in my class, which was about maybe 110 students, I think we had about 20 Mormon people because we had this pipeline coming from BYU undergrad. And like I said, they're awesome and so nice, but they don't have a lot of diversity experience. And So, if you don't have experience, some things you'll just never even consider. You'll never. It's just something you don't know. It's a lack of experience, a lack of education, and that's, I don't know. This is a pretty random tangent, but what I meant to talk about was, number one, a reminder that I will sing for money, and I wanted to add some more musical artists to the list of people that I will sing the song. So Bieber is my man. Bieber is my boy. I will sing Bieber songs. I will sing certain Justin Timberlake songs. And then there's a lot of female artists that I love. I think maybe I already mentioned Rihanna and Lady Gaga, but I think they're incredible. And the Star is Born soundtrack is pretty awesome. And in terms of Bieber, I just came across this old video. It's like 18 years old, and it's Justin Bieber playing the guitar and singing Cry Me a River by Justin Timberlake. And I thought, man, that's so cool because I don't know, it's kind of an iconic performance in my opinion. And it was before Bieber's voice changed. So he really had an amazing high voice, but it's really good. And let's see, I like his main, I don't think, I wouldn't say he has like a ton of songs that I like, but the ones that there are probably like 4 or 5 that I do really like. Oh, also Post Malone. Post Malone's great. He's got a great vibe and fun music, and he can kind of be uplifting. Let's see, Prince is like probably too much for me. I don't think I could pull that off as much as I would want to. It's good to know your limits. And Prince, I don't know if I could do that. I could try to rap if you want. Eminem. Let's try for one of the less violent songs because Eminem has some really dark music. But it's an example. I do think he's one of the best, and some of his songs are amazing just in terms of storytelling, but also the craft of writing and the sounds that he puts together. I think I've seen some videos of where like, other artists are saying, yeah, Eminem is the best. And I think he has sold the most records, and that's one way to measure it. Snoop, I love Snoop. It's just effortless flow and smooth MFer. Legend. He's such a personality and just positive. Great for art. Obviously Dre. I mean, I would. I don't think I match his style the best, but there's some songs I would try. I probably couldn't do Ice Cube very well, but I could try for money. Let's see. I mean, those are some pretty awesome ones. Beastie Boys. Can you believe they're from the 80s? Okay, so back to my legal education. So I went to law school from 2010 to 2010 to 2013. So 1L year, for those who haven't been, 1L year is the hardest, and you read a lot. And just for me, it's not like I was straight A's guy at all. Not in undergrad, not in high school. I was like B+ guy, which thought was fine. But here's the thing, that would be my overall average, but there are specific classes where I could get an A, or rarely, but occasionally I could get an A+, and mainly if it was a writing class. And I think that's part of my introverted nature, to just really think. And also my creative artist side to work super hard on my craft as for writing. And one of the lamest, cheesiest, but true things about this is people say, I don't like writing, I like having written, because writing can be really tough. Just like any craft, if you're really disciplined, almost like martial arts, you have to stay true. And that means you don't accept something less than what you're working for. And so you might have draft after draft, and you might be sick and tired of a piece of writing, but I did that for long enough to where that was my skill. That was my marketable skill, because that's kind of the idea of going into law school, is to raise my game, get some marketable skills where I can go into the job market and compete better than I would without a law degree. And to do that, you have to have skills. You have to be able to get the job done. And so writing was my focus. But there's also another aspect to it, and that was, so I did debate in high school and college, policy debate. I have talked about this briefly on one of my videos where I did like an hour and 38 minutes educational video on oral argument at the United States Supreme Court. And I think I speed read the first part of the Constitution. And that's because that's in policy debate, that's what you do. In high school, we had 8 minutes, and you are supposed to, or it's thought that you only have 8 minutes, so you try to make all the arguments that you can in that amount of time. And so people really go fast. This is like, here's a book, The Elements of Style, William Strunk Jr. and E.B. White. And let's see what the first page says. Forward. The first writer I watched at work was my stepfather, E.B. White. Each Tuesday, he would close his study door and sit down and write the notes and comment page for the New Yorker. The task was familiar to him. He was required to file a few hundred words of editorial personal commentary on some topic in or out of the news that week, but the sounds of his typewriter from his room came in hesitant bursts with long silences in between. Hours went by, summoned at last for lunch. He was silent and preoccupied, and soon excused himself to get back to the job. When the copy went off at last in the afternoon, RFD pouch, we were in Maine, and a day's mail away from New York. He rarely seemed satisfied. It isn't good enough, he said. I wish it were better. Writing is hard, even for authors who do it all the time. Less frequent practitioners, the job applicant, the business as an executive with an annual report to get out, the high school senior with Faulkner assignment, the graduate school student and with their thesis proposal, the writer of a letter of condolence often gets stuck in these awkward passages or muddle on the screen and then blame themselves. What should be easy and flowing looks tangled or feeble or overblown. That's not what I meant at all. What's wrong with me? And one thinks, why can't I get this right? So that's what we would do in our speeches. And I'm actually slower than average among the like really competitive people. They're much faster, but I was good at argument selection and then prioritization, like the comparison and preparation too. So those are all skills I worked on before I went to law school. And that, people ask me like, why did you become a lawyer? Why did you go to law school? That is kind of the beginning. The origin story is my sophomore year of high school at Westside High School in Omaha, Nebraska. You are supposed to have an elective, either debate or journalism. I think those were the two. And I don't know if those are the two I knew about. I don't know if like band is, I know band was a class, but I don't know if it was like band was the third option, or I don't think it was. I think you had to do either journalism or debate. And we only had maybe like 25 debate people. So I don't even know what happened, but I did debate. That also involves, I think that was both semesters, fall semester and spring semester, we had debate maybe like 4 or 5 tournaments a semester, probably more than that. I don't know. Maybe let's say 4 or 5 Saturday mornings where you're doing that speed reading thing. Each round would be like maybe 2 hours, maybe a little less. And you might, on a really long day, you might have 6 debates. And you're supposed to go pro or neg, and you don't know which one you're going to be, but you prepare beforehand. And then you find out like 10 or 15 minutes before the round, are you pro or neg and who you're going against? And there's a lot of scouting, like you'll know, oh, this school argues this. And sometimes you could debate the same team, but it's flip side. So you wouldn't debate the same team arguing pro both times. You would try to beat them on the pro side and then see them later and try to beat them on the negative side. Those are really good skills. It's the critical thinking. It's just learning about random stuff I never would have known about. It's getting comfortable with the public speaking and kind of being yourself. Sometimes I remember just like even raising my hand in class and giving an answer would take a lot from me. I'm introverted, and when you're young, you don't really think that you need to say anything, or I don't know that you don't. I don't know. I was just such a listener guy all the time. Like, I'm just really more interested in listening to what people have to say. I think that I learn a ton from that. It's a great observational thing, and I still use it all the time in lawyering, is you have to listen. And I would do that so much. I would almost be like, hey, can that guy even talk? And so still to this day, like my strength isn't speaking, it is writing, but I can do the speaking. And the thing is I haven't even gotten to my whole background yet, but I try to be well-rounded, and I purposely went out there. It's all education based, but I tried to get different total experiences to where I've told 2 stories about how I was working with a plaintiff's law firm in private practice. But I have another 2 stories I could say on the defense side that are not as good, but they are impressive, and I am proud of them, and they took a lot of work, and they helped me elevate my game and become the man I am today. I can tell you briefly the 2 ones that I have in my mind, but I could try to think of some more, were in Colorado, and I was at a defense firm in Denver. And the first one was I was defending a civil rights case. So I told you about the Daniel Reds case. We were plaintiffs, and we sued the Omaha Police Department for an excessive force claim, where the claim was that my client was about to get arrested for disorderly conduct, but he told the officer before being handcuffed that he had just had rotator cuff surgery, and therefore he said, if you're going to cuff me in the front, not the back. And the officer was really mad and angry, and he said, I'll show you how far back it can go, and cuffed him in the back and ruined his surgery, retore his rotator cuff. And if you look at the last stream, the result was an Omaha jury in federal court found against the officer, and that decision was affirmed on appeal. So this is different, and I don't think I've shared this on my channel yet, but the next case, this is while I was at a defense firm. Part of our practice was to defend against civil rights claims. So this was this is constitutional law, and it is also the Fourth Amendment, and it's also an excessive force claim. But this one was a death, and what made it unique was it was an officer killing another officer by accident. This happened in Lakewood, Colorado around 2014. And the scene was I'm going to say there was a Hispanic home. There was like a party, and people were kind of assuming, but they were firing off their guns in the air. And so this got a response, and actually got a response from eventually it was the Lakewood police, but their SWAT team, because they got on scene and they were trying to talk to the folks inside the house. And so they had a negotiator and they were trying to make contact, and it didn't work. And so they thought that there was something called a barricaded suspect, or like a hostage inside the house. And so they were preparing to breach the house and go inside. And so what they did was set up a perimeter around the house. And this involved a backyard. So we defended one of the sergeants on the SWAT team. He was a supervisor and a negotiator. And I think he went in the front with some other officers. When they went inside, I think there were some dogs in the bathroom, and some people were like behind a closed door in the bathroom. So there's the Lakewood police breaching the entry and trying to find the people and secure the scene. But so they go in, and as I remember, I think this bathroom door is closed. So they're trying to secure the scene and search the rest of the house. So they, I think they went left, and that there was this carport which led to the backyard. So some of the officers were sweeping the area, and they go out to the car park and they slowly go into the backyard. But they're also trying to clear it to make sure there's no people in the backyard. And one of the officers on the same team stuck his head over the fence in the backyard and said something. And another officer, not our client, but one of his subordinates, shot and killed the other officer. And so this resulted in a lawsuit against the city of Lakewood, against the officer that fired the shot, and against the boss of the officers that fired the shot. And we were representing the boss. And so I was in federal court again, this time in Colorado. And I was learning a lot about supervisory liabilities. So not the one who pulls the trigger, but the boss. And this is a case that we won on motions. It didn't even go to trial. We filed a motion for qualified immunity. And part of it is this is supposed to be a constitutional claim. And that means, usually it means something intentional happened. Like in the Daniel Retz case, it was the officer pulling the injured arm backwards and handcuffing it. And the jury had to decide, was that on purpose or not? And they found that it was. So this is more of an accident, this Colorado case. That's just, the case wasn't litigated like that. The plaintiff's firm was trying to be creative and make some new categories of claims that didn't really exist. It's because negligence is not supposed to be a constitutional violation. It's an accident. There's supposed to be at least what's called, I think this is for the supervisor, but deliberate indifference. And that's basically intentional. It's a degree of intent that is not easy to prove. Maybe it's just below specific intent, like acting with the purpose of shooting the officer would be the most specific. and deliberate indifference would be a little bit less than that, maybe a little bit more than recklessness. It is essentially intent and knowing something that was going to happen and disregarding the situation and not really caring what happens is my off the head definition. And for the legal art nerds out there, you might know what the test is. So for qualified immunity, it's something that police officers have a chance to be immune from suit and to pierce the immunity and require the officer to go forward to trial. The plaintiff needs to prove that a constitutional violation actually occurred, which we were arguing about, saying it was basically negligence, an accident. And then 2, the constitutional violation was or violated quote unquote clearly established constitutional law, meaning this wasn't something that, or the officer should have known about this because there's other examples, there's training, this has happened before, other officers have gotten in trouble for this exact same thing. And if you, especially in federal court, the United States Supreme Court, they really believe in a strong qualified immunity in this second prong, clearly established. The clearly established prong, that can be a huge obstacle for a plaintiff. And I haven't done this super recently. Like I haven't worked in this area super recently, but I remember having a lot of confidence in that argument specifically, that our supervisor didn't violate clearly established law. And I think that some of the plaintiff's arguments helped us with that because they were trying to tread new ground or come up with a new theory to fit their facts, which it normally doesn't work, but especially in this scenario, it was not going to work. But I had a good experience because even though I was somewhat young, let me think, I would have been, I guess, 30, which was only a few years after law school. I actually got to argue this motion in federal court in Denver, and it was with some much more experienced attorneys than me, but I had an awesome argument, and even some of it was like cutting edge, like uncertain, like we need more cases on this to know what to do, but I actually dealt with that fine. And I don't know, it's definitely a feather in my cap, because the other attorneys, like this is their practice area and they've done this for a while and much more experienced and successful than me, but I just had my debate experience plus my Emory University debate experience, which I skipped over. Maybe I can talk about that more another time. But in terms of the defense side, that's the one I wanted to share with you today. Was I have experience on the defense side defending against constitutional Fourth Amendment claims. And then the other one, so the other one is also cool, but I feel like it's a little bit more boring of a story. But it involved, I was defending a securities lawsuit, securities fraud. And I don't know, maybe I can talk about that one in another stream and kind of prep it more and get you more prepared. But we had a little more context. It was in Durango, Colorado. It was a 2-week trial. It wasn't a jury trial. It was a bench trial, but there was about $5 million at stake. And if our clients lost, they would have had to pay that. And surprise, we won. We got an entire defense verdict, meaning we paid $0, which the plaintiffs were pretty confident. And they had this dude from Harvard that was so smugly and overconfident, because when I was working on this case, I was like, man, we actually have some pretty good facts. What is this dude riffing about? But it was in Durango, and the plaintiff was the First National Bank of Durango. And they were saying that they issued some bonds and the bonds failed, and that they were defrauded when they issued the bonds because they some of the disclosures weren't accurate or something like that. Or no, they were materially misleading in connection with the sale of a security. That's the language, but we actually won in the merits. We had a whole bunch of like I don't know. Actually, that one might be interesting for the legal nerds because we had some good legal strategy and we executed it. And it was, like I said, a 2-week trial. So we kind of had to survive the first week, which was the plaintiff's case. And the trial is kind of like, or it's like a drama where you have the plaintiff's case. And if you're the defense, you're going to take some hits. But if you can get through the first week, because that's supposed to be like the best evidence against you, if you last for the first week and you still have a chance, then you're doing pretty well, because then it's going to be your case. And if you can even it up or even get a little bit ahead, then you'll be in a good situation. But we had kind of this procedural head fake because there was an earlier appeal in the case, and there was some interesting language in the Court of Appeals opinion, because the case was sent back to the district court, and it was a bench trial. So the judge was going to be the one to make up the decision about what happened at the end of the day, who won. And we had like some parts of the Court of Appeals opinion that we were hanging over the judge's head. And it was good enough that it really distracted our opponents. Like, it was a total head fake. They focused on that, because if we had won, I don't know, like, it was a good argument, but it's hard to say how like true or how developed it really was. But it made sense to me, and we were really able to maximize the value of it, because we had this procedural head fake and our opponents were distracted by that. Meanwhile, we were proving our case with the actual facts. And I feel like our opponents were missing that we were disproving their materially misleading facts. And they almost didn't even think about that, or didn't even notice that was happening. But we're like, look over here, keep your eye over here. We have these procedural arguments, and they're purely legal, and they came from the Court of Appeals, and that's supposed to be a mandate. The trial court's supposed to be bound by that, have no discretion to depart from that. And that was a cool strategy, because it served its purpose, but also it gave us cover to prove our case in a really strong way, to where when the trial was done, we go back and read the transcript and look at all the exhibits and stuff. And it's like, wow, we totally proved our case. Look, they totally missed what even happened. It's like, were they even there? And one of the big labors, so that took a lot of work. Like, every day was probably, I don't know, 14 hours or more of work a day. But I was doing the defense work, so I got to bill all that time. And on weekends, we probably only worked like at night or something. Like, we mostly had weekends off. But it would be every morning that we would work, and then trial from, let's just say, 8 to 5 or something like that. Can't remember what it was, and then at night we would work. So and then we did that for 2 weeks. So that was a lot. But then when it was done, I wrote what was called the proposed findings of fact and conclusions of law. So it's kind of like taking that 2-week trial plus all of the litigation that happened before, which was a lot. There was years and years and years of stuff because the actual claims were based on the housing market crash in 2008. And the sale of the bonds probably happened something like 2007, I think. So, and the trial was 2015. So there was just a lot of backstory, a lot of exhibits, a lot of evidence, and it's stuff it probably was my first exposure to a lot of this stuff. Reading something called an LOM, a limited offering memorandum, which is essentially what do I call it? Like a sales book, or so. It's information about the bonds, and it's supposed to talk about the risks and the expected yield. And it just is the reason why they call it limited is it only goes to a certain number of potential buyers. And I think that each of them have to have some special classification where they have like certain amount of cash, certain credentials that show that they're an institutional buyer, that basically this is what they do and they're a bank and they're not just or that they can make the bonds yield and successfully. So it's part of the bond selling dance is this limited offering memorandum, and then the actual offering memorandum. I'm not sure how many that went to. Maybe only the buyer, but First National Bank was the buyer, and their claim was that there was some material misrepresentations in the limited offering memorandum and offering memorandum. And we had a 2-week trial about it. But we kind of thought that the plaintiffs didn't have a very strong case. It was pretty obvious that this is all about the housing market crash and not about any representations. So the plaintiffs were the banks, but the dudes behind the banks were billionaires. So they do litigation for sport, and we even had some evidence saying that, proving that this is what they thought. This is how they thought about it. It was like sport, and they had lost these bonds because the housing market crashed. They had lost these particular bonds, so they're like, let's sue somebody, maybe we'll get some of it back. And they acted so confident, maybe because they thought they had the home court advantage in Durango, but they just didn't have a very strong case. A lot of it was innuendo, like, oh, isn't that so misleading? But they didn't really prove it. And also, like, again, the housing market crisis was obviously was the reason why it went this way. So that's they had a kind of a lack of common sense, a lack of logic. And okay. But here's the other thing. So I mentioned my plaintiff's personal injury experience, private practice, defense experience, Section 1983, securities fraud, private practice experience. But here's the thing. Here's my actual favorite experience is working as a judicial law clerk. And I've done that a ton. So I've done that for probably 7 or 8 of my 13 years of legal experience. And this is why I'm saying the judicial branch is my favorite branch. I get to be in the middle and call the balls and strikes and evaluate the different parties' arguments, synthesize them, read the evidence, read the case law, and figure out who wins and why. And that was really fulfilling for me because intellectually challenging. I'm always learning something. And then I feel like I'm contributing to the law. I'm giving people clarity on what the rules are, what it takes to win the case. And then one of the things, so I worked, so one of my judicial law clerk jobs was for 8 judges in trial court. And so trial court is things move a little bit more quickly. There's 8 courtrooms. There might be different stuff happening. There might be trials happening in these courtrooms. Who knows? Maybe there's some crazy hearings in another courtroom. But there's always something. And it was in Lincoln, Nebraska, which is our state capital. So it's also what they call like the seat of state capital, which they get the hot button political issues come to them, at least first. They were never the final decision maker on any of these, pretty much. It's sort of known that when these political lightning bolt cases come in, they start at the district court in Lincoln, and then they're going to get appealed to the Nebraska Supreme Court. But we would get the first shot at it, and people would come in, and sometimes that does put pressure on the judge. And really all they're interested in doing is getting the right call and making it fair. So one of the rules that we had was when you write up a decision, one of the things you can do is write it in a way so the losing party gets something out of it. You're kind of talking to them and explaining why it didn't work out. And you're showing them that you really took it seriously. You consider what they said. And you go through what they said and say, we did hear you. We really did. And then give them the bad news. But that is an effective way to give a case the amount of consideration that is due, which it should be really professional. You don't want any kind of offhand or any comments or anything that's less than very respectful, very neutral, very much application of law to fact. Nothing that makes someone pause and second guess and question, and put a lot of work into that. So that's one of the time periods that really molded me. That's when I was becoming more of a man, because even when I was 30, I was still like pretty immature and still growing into myself. And I'm probably somewhat of a late bloomer, but I really invested all those years, law school. Even today, I invest so much in education, always to make myself more better, well-rounded. And I'll talk more about my judicial clerkship experience later, but let me just tell you how I think I fit into LawTube, which is I think I have more appellate experience than your average LawTube person. And I think there's a lot of LawTube people I haven't seen, like Legal Eagle or something. I don't think I've ever watched one of his, and I think he's one of the most viewed people, and I don't think I've ever seen one of his. I have done let's see, what's her name, Karen Baker or Emily Baker. Yeah, Emily Baker. She's great. She's funny. She says the cuss words, and she's experienced enough to give you a really accurate take on what's happening in a court. It seems to me that she could have been a judge. That's why I like her, is she gets it, and she is pretty fair. But she'll tell you, just being fair doesn't mean you have to be in the middle. You can be fair and be 100% on one side, and I like that when people are real. But I do think that she's not really the super law nerdy lawyer. In my opinion, she's more of a trial lawyer and more of a criminal prosecutor lawyer, which I think she's a great example of that. But it doesn't mean that it doesn't mean she's covering everything. There's probably, in general, there's probably a lot of civil stuff that she wouldn't be the person to go to. And if she could cover it, but she just wouldn't have the same amount of experience and expertise that she does for a criminal trial. Because criminal law is simple. It's fairly narrow, and there's not a lot of surprises. There is the same arguments have been going on for like hundreds of years. And pretty much people know the situation and the expectations, but it's big stakes. It's people's freedom. I think a lot of the criminal law is the burden of proof and trying to get the facts. And then it is an area where I think it's super political. The prosecutor sometimes is appointed, and they pick which cases they want to prosecute and get a conviction on. And so if I were to, I don't think criminal is my favorite judge. My favorite judge has some criminal, but they have plenty of civil, and they're just good on the law, and they might not be your best candidate for a trial judge, which is really more admin work. It's the due process venue where you're just supposed to hear people out, give them chances, and then make your call. But don't make a call without giving chances. It's the day in court judge is the trial court judge. Have hearings, call them in, give people opportunity, ask them, do you need to do anything else? Do you want to have any other evidence? Do you want to have any other exhibits? Hey, I'm really, really wanting to hear from you. What do you now's the time. Tell me. And then make the call. I feel like that is what trial court is about a lot. It's not really a perfect application of law. It's we're busy, things are moving, make your record and let's go. Whereas appellate court is almost all law. It's reviewing cases a lot slower and making sure the history and the origins of the law still match up with the law as we see it today and the law going forward into the future. And so that is, you get your classic argument of breadth versus depth. What do you prefer as a lawyer? Do you like to have a lot of cases that you get to do a little bit on and you just do a ton of different projects? Or do you have a couple and it's like as deep as you could possibly go into the ocean on just like one issue or something? Pick which one you would rather like. And I'm a little bit more of the latter, where I also like to play chess. I'm not like really great, but I'm a fan and I follow it, so I can appreciate it. And I really like the calculating ahead and seeing the end game based on what you know in front of you. And I think that's an awesome skill to have. And to do that, you need to have studied things at sufficient depth, because you can start, once you have a process for that, you can start to see things take shape as you're working on them over time, as things are developing, and you can kind of see the end game. And I think that's more about the appellate courts. It's supposed to be the final word on the law. It's much more in depth on specific things, and you do pretty much get an answer. One time I was doing a panel at law school, and when I went back to teach some of the students, and they asked a question like, when you're writing an opinion, do you try to be persuasive or do you try to be accurate? And the truth is you do both. By the way, this is brought to you by Smoothie King. That's so good. Also, how do you feel about this right here. It says, I really need a day between Saturday and Sunday. Do you agree? Tell me in the comments. Yeah, there is a way to work hard enough on something that you can come up with a really thorough answer that is not ideological, that fits with the examples that have come before, and that set out enough of a roadmap for cases that come in the future. This is going to be clear enough and people will know how to decide it in the future. That's what I really like. And so you need to have that long view, and it's kind of a trip working on those skills, because you're going back like 100 years or 150 years and you're just digging deeper and deeper. And that's like a mental challenge sometimes, to keep working on it, make it better, make it right, go back in time and line everything up and fix it on this one thing. I'm kind of proud of some of that, because once you do that, now you've acquired a skill and you can look at cases and you can possibly see the end game, because you've had other cases where you've done that exercise and you've played things out and you've gone all the way into the earth's crust and you've seen what's there. And so when it's time to do your next assignment, you can almost see things so you can almost see the future. It's true. Like, it's absolutely true. And you won't be able to predict it perfectly. And there's probably some things that are off. You're not going to get all the details, but you can get a lot of things correct by prediction. And that's really not, people might be a little skeptical, but that's pretty much business. I think that's how businesses are run. I don't have an MBA. I should, but businesses are like that. There's a lot of planning, a lot of predictions, a lot of risk assessment, and a lot of unknowns. But I think that businesses are dependent on the idea that they can predict the future. And it includes assumptions in there. Certain things need to happen, and there's probably some percentage that certain things are not going to happen. But all that's factored in, and you can almost, if you're someone who gets good at this, you can get a second sense and you can evaluate things, and there you go. That's your professional advice and judgment, that as a lawyer, that is your skill that you're bringing to the table. And that's why people are going to pay you whatever they're going to pay you. This is your professional knowledge, skill, background. You know stuff. You've seen some stuff. I've seen some stuff. And you can look at someone and say, or look at their case and say, you don't want this is going to lose. That's most of the time, is you're telling people why they shouldn't get in a lawsuit, because you never want to be in a lawsuit. It's no fun unless you absolutely have to. Then you can justify it. But it's a huge expense, time commitment, energy suck. And it can, there's this phrase that I first learned it in the context of Phil Jackson, the basketball coach who had maybe he had a coach before him called Tex Winter that said things turn on a trifle, and that is true. Something small can throw things off. Like in a lawsuit, there's two sides going against each other, and sometimes it is pretty dang close on who's going to win and what issue. But there can be this little difference, and the little thing sparks a chain reaction. And if one party slightly wins on one issue, that can dictate how the rest of the case goes. So I did say that I'm gonna go pretty soon, but I did mention Bieber before, so I'm gonna try to sing a little bit, and it's because I saw his YouTube video from 18 years ago where he sang "Cry Me a River," and I feel like that was one of the first JT songs that I really liked. I think it was well produced and it was like really good. So he goes, "You were my sun, you were my earth, but you don't know all the ways I love you. No, but you took a chance, made other plans, but you didn't think that they'd come crashing down. No, no, people." Okay, anyways, that's a good one. I think I was at debate camp. I remember that must have been in high school when that came out. I think that was like 2002 or 2003 or something, a long time ago. All right, everybody, I'm going to wrap up, but I wanted to tell you more about me, how I fit in. I only really talked about Emily D. Baker. Okay, quickly, I'll mention a couple other people. I don't know Legal Eagle. I know Runkle. Runkle, I think he's more of a criminal defense attorney, and he has done a lot more trials than I have. He is the master of hypotheticals. He loves to think about this stuff and apply them to different situations, and it seems like he has a lot of trial court experience. He said he is a GUN law attorney. That seems pretty interesting. He fancies himself an appellate attorney. I want to see like how legit that really is, because he said he's had like a case or two. I don't know. I want to see more from Runkle on his appellate knowledge, because I'm sold that he is an experienced trial advocate and can really. One of the things that I can't do is read witness testimony in real time in terms of like how it's coming off and what questions to ask. I feel like he is such a grasp on that. He can be like, oh, this person's lying because they said it this way, and here's the question you need to ask if this circumstance comes up. That's why I really like watching him, is because I learned so much in real time, or somewhat like that, from his observations. But I don't think he is the super appellate law legal nerd. And why I say that sometimes is because he's too optimistic in his legal arguments. Sometimes appellate law is harsh, and probably you can't just come up with a good argument. It takes a lot more. It has to actually be the law, and it has to actually fit. And so something can sound great, but ain't good enough a lot of the time. There is the Lawyer You Know. I think he seems like very hardworking and big aspirations, and now he's in personal injury. I don't know. I think I'm a fan. He seems really nice and likable, but I wouldn't hire him as my lawyer if I needed a lawyer. That's just because I think there's better lawyers. Like I think Runkle's probably better. Emily D. Baker's a better lawyer. What's her name? Andrea or something. I can't remember. I think Lawyer You Know is certainly riding his dad's coattails. So good for him. I mean, if you got it, go for it. But I feel like you get the really great legal analysis when his dad comes on. And it's just a huge difference, in my opinion. There's also Brother Counsel. One thing about Brother Counsel is I feel like he is probably a great trial lawyer because he's so into the facts. He loves facts. He loves facts kind of how I love law. Sometimes I don't love facts because they're hard. Like it, it could be about just an area. A dispute could be about an area of life that I just don't have a lot of experience in, and so facts are hard. They take me a while to get the picture. And also, I'm still going through the process of who do I believe and whose testimony do I credit. And so sometimes that takes me time. It's like I can't really know the factual landscape right away. And I think his strength is he is super attention to detail oriented, and he's going to know the facts. If some issue comes up, he's going to know what's been said and is this consistent or inconsistent with what they said before, and potentially why does that matter. However, I think he's said before that he did some like Court of Appeals thing in Minnesota or in Michigan, and I haven't seen it. So I am kind of talking out of my behind, but I still don't even get the sense from him that he is a super law nerd. He is a nerd, but I think his strength seems to be the facts, and it's a really strong strength. I think I would probably hire brother counsel as my lawyer. I would probably feel comfortable that he's hardworking and exhaustive, and he seems like fairly compassionate. So I would hire him. There's probably a million others, and those are the main ones that I've seen and that I have opinions on. And I think I'm offering something different because I'm probably less serious. But when I get serious, I can get like philosophy, like let's think, let's do some crazy hypotheticals like Uncle likes to do, but let's actually understand the law. And that can be a trip sometime, but it can maybe lead to some fun conversations. But I want you all to tell me what you want me to present on. I'm just trying some streams. This is my third one. I'm just trying it out. More videos, the better. And probably in the future, I'm going to talk a little bit more about those defense cases that I talked about. Maybe I can do a little bit more on the securities fraud trial. There's some appeals that I haven't talked about that I've done, and some appellate court clerking that I've done that I could do way more in depth on. But I just wanted to tell you a little bit about who I am, where I'm coming from, my background. I didn't tell you about my Emory debate either, but I told you enough, I think, for one day. So let's call it a day. Oh yeah, I also sang you a song. So if you all want to give me money for that, I think I've earned it. But other than that, maybe you can have one free sample. And if you like that, offer me money for a different one. My top preferences would be The Journey, Queen, The Beatles. Try one of those and see if you can make it work. With that, my friends, let's have a good weekend, everybody. Go and squeeze your dog and give him hugs and kisses and treats and belly rubs. And remember to love, dream, smile, and increase the peace.